I'm Lawrence Simon.
Hey, I'm Shivam. This is Channel 4 News, APNSL edition.
Today we have a lot to report on, like the flamboyant issue of gay marriage.
We will hear from expert reporters, but first we will start with court cases. What many people may or may not be aware of is the current court cases that are occurring in relation to gay marriage. These cases are Winster versus U.S. and Hollingworth versus Perry. In Winster versus U.S., Edith Winster, who is the surviving spouse of a marriage between a same-sex couple whom married in Canada in 2007, who was also having a valid marriage in New York when her spouse passed away in 2009, and when she was denied estate tax spousal exemption, Winster sued since she was forced to pay an estate tax of over $363,000. In the district courts, which there are 93 of, it was ruled that Winster was wrong and proved that DOMA was unconstitutional. Then when she went up the federal train track into Circuit Court of Appeals, which there are 13 of, she was again proven to be right. To ensure that she creates public policy, Winster filed for a writ of certiorari for her case to be heard. And as many may not know, besides the APNSL students, that the Supreme Court only grants certiorari to about 1% of cases, since to grant cert they must have 4 out of 9 judges. By granting certiorari, it doesn't necessarily mean that the cases have been decided one way or another, but instead means that the justices have determined that the circumstances described in the petition are sufficient to warrant review by the court. Winster had oral arguments heard recently after they filed their brief, which are written arguments to show why a case should be decided the way, and to prove a more promising case, many people file amicus curiae briefs on behalf of the people fighting for the same cause, since they want to help them by being friends of the court. Another case that was granted cert was Hollingworth versus Perry. 2 California same-sex couples filed under 42 U.S.C. 1983 in the United States District Court for Northern California, alleging that Proposition 8 violated the 14th Amendment equal protection guarantee of the United States Constitution, which showed that if a state creates or amends their constitution and it goes against the supreme law of the land, the United States Constitution, then the amendment that was added to the state's constitution would be considered unconstitutional, which matched the opinion said by the federal district courts, since all federal cases regarding the constitutionality of anything start there. Then later proceeded to the 9th District Court, which agreed affirming the district court's ruling. The United States Supreme Court will now consider whether a state can define marriage solely as a union of a man and a woman, in addition to considering whether the proponents of Proposition 8 have been standing to bring suit in federal court. The court's ruling will implicate the rights of gay men and lesbians. After learning about all these cases, it helps come to an inference of how much power is bestowed upon the Supreme Court through their power of judicial review, which allows them to check the constitutionality of any court case. They gain this power of judicial review through the court case of Marbury versus Madison, which happened to be an activist court decision, which is when the justices interpret the decision based on current situations, since the Constitution is written in an elastic language. But however, the other ways to interpret the Constitution is by a strict philosophy, which takes the literal word-for-word definition of the Constitution, which causes issues, since many believe that the Constitution should be used in an activist manner, since back then they didn't have the similar issues that we deal with today, such as gay marriage, gun control, and abortion. To ensure that the justices aren't forced to rule in a certain way, they are elected for life, which means that they don't have to worry about how they rule, and they don't have to worry about losing their job just because they rule that way. When the case is finally decided, there will either be a majority opinion in which the majority of the judges agree with the ruling, a concurring opinion in which they agree with the ruling but for different reasons. A dissenting opinion is an opinion that they agree with the deposition. The writing of opinions is assigned to by the Chief Justice of the court. The fight for these cases will help determine the legality of gay marriage through the United States. Next, Lawrence will be going more into depth on the flamboyant issues of gay marriage by talking about federalism, DOMA versus state laws.
Thanks, Shivam. Since 1996, the Defense of Marriage Act has defined marriage federally as being between one man and one woman. There has recently been a great deal of controversy surrounding state laws versus federal law on gay marriage. States are usually expected to define marriage at their own level, as allowed by the 10th Amendment to the Constitution, which allows states to pass laws on subjects not specifically given to the federal government. However, the federal government's role in defining marriage has been assumed under the ability to unify federal law codes, an extension of the federal government's power to regulate interstate commerce. States have found many ways to define marriage for them. So far, 32 states have used statute and amendments to their constitutions to restrict same-sex marriage. Other states must follow what other states have set out in their jurisdiction according to the full faith and credit clause of the 4th Article of the Constitution. However, this has also worked to the benefit of states who allow for same-sex marriage. Since 2004, when Massachusetts first became the first state to allow for same-sex marriage, states have used judicial activism, courts using their power of judicial review to change policy, as well as their own statutes, initiatives, and referendums. Maryland used referendum last year after the law passed the state legislature and the proper number of signatures was collected by petitioners. California has used the most famous example of initiative by using Proposition 8 to define marriage as between one man and one woman, something that has been challenged in the courts. Most recently, Minnesota has used statute to allow for same-sex marriage on May 13, 2013. To see how political parties have affected same-sex marriage, we now turn to our very competent political party analyst, Jack Ploshnik.
Hi there, I'm Jack Ploshnik with NSL News, your political party analyst. Gay marriage is an incredibly politically polarizing issue with both parties having strong opinions on the topic. In the Democratic Party's platform for the 2012 election, they stated, "We support marriage equality and support the movement to secure equal treatment under the law for same-sex couples. We also support the freedom of churches and religious entities to decide how to administer marriage as a religious sacrament without government interference." The Republican Party platform stated, we believe that marriage, the union of one man and one woman, must be upheld as the national standard. These opinions support the generalization that we learned in class that Republicans want government to be involved in social policy, whereas the Democrats want the government involvement in social policy to be limited. Hi there, I'm Jack Ploshnik with NSL News, your political party analyst. Gay marriage is an incredibly politically polarizing issue with both parties having strong opinions on the topic. In the Democratic Party's platform for the 2012 election, they stated, "We support marriage equality and support the movement to secure equal treatment under the law for same-sex couples. We also support the freedom of churches and religious entities to decide how to administer marriage as a religious sacrament without government interference." The Republican Party platform stated, "We believe that marriage, the union of one man and one woman, must be upheld as the national standard." These opinions support the generalization we learned in class that Republicans want government to be involved in social policy, whereas the Democratic Party wants government involvement in social policy to be limited. These opinions, however, have not always been held. While running for the office of president in 2008, President Obama openly stated that he was against gay marriage. The 2008 Democratic Party platform did not explicitly support gay marriage either. The President and the Democratic Party have, however, both reversed their opinions. This clearly demonstrates the move towards allowing gay marriage. I predict that by the 2016 election, the Republican Party will openly support gay marriage. Now over to David Ritchie.
Here's some polls and statistics about the nation's view on same-sex marriage. Out of 1,000 likely voters, 40% said they support marriage equality. Next, 36% believe that each state should make its own law on whether same-sex marriage is legal or illegal there. 57% believe it should be decided for all states on the basis of the U.S. Constitution. This is significant because it reveals that citizens want nationwide change on gay marriage. Also, over the past 8 years, every state has increased its support for same-sex marriage with an average increase of 13.6%. young Americans are more likely than older Americans to favor gay marriage support. 12 states legally recognize same-sex marriage, and polling conducted in 2003 found most Americans, 58%, opposed to allowing gays and lesbians to marry legally, and just a third in favor. Lastly, a new survey conducted March 13th through 17th among 1,501 adults nationwide confirms that these figures have crossed, with 49% supporting same-sex marriage and 44% opposed. These polls express that public opinion for same-sex marriage has not always been so high. It only recently grew in size due to the millennial generation and the growing support for civil liberties. There was low support for gay marriage in the past, therefore, those in favor of same-sex marriage had to go to the courts to get legislation passed. Also, these past couple of months were gay marriage bills introduced in Congress. Public opinion polls are important because high public opinion for an issue encourages the president to persuade Congress to pass bills relating to that issue. In this case, this allows more same-sex bills to be put into law, protecting their right of marriage. Low public opinion for an issue causes the issue to not be put into a political agenda. Public opinion polls also represent the country's view on issues.
Why, thank you, David. As you fellow viewers may already know, homosexuals have never really been allowed to serve in the military. Well, that is until more recent history, but I'll get to that later. Throughout the early parts of American history, gays were heavily discouraged from joining the military, but there wasn't a formal ban on homosexuality in the military until World War II. Many people thought that homosexuality was a psychological illness, and if these people were allowed in the military, they would jeopardize the military's high standards of morale, discipline, and capability. Therefore, homosexuality was considered a disqualifying trait from the military. But during the late 1980s, there was a huge surge in public support for gay rights. And when Bill Clinton became president in 1992, he promised to allow any citizen to serve in the military regardless of their sexual orientation. Unfortunately for him and many other Democrats, there was a healthy number of Republicans in Congress at the time, most of whom strongly opposed allowing homosexuals into the military. After about a year of compromising, a deal was finally reached and the Don't Ask, Don't Tell Act was formed on December 21, 1993. This act still maintained a statutory ban of homosexuality in the military, meaning if you identify yourself as being gay or lesbian, you will be denied entrance into the military. But this act also forbids commanding officers from questioning one's sexuality. So as long as a homosexual doesn't reveal that they are homosexual, they will be allowed to serve in the military. About 17 years later, another wave of gay rights activists appeared in the United States. They pushed for equal rights for homosexuals, which include the right to openly serve in the military without fear of being mistreated or discharged for their views. Later in his first term, President Obama supported this growing trend, and with a majority vote in the Senate, he successfully repealed the Don't Ask, Don't Tell Act in September of 2011. So now, people cannot be denied entrance into the military based on their sexual orientation. Back to you, Shivam.